Well, good morning, everyone. By my unofficially official time clock, I have 10:02, so I think we have given folks enough time to go ahead and get situated, grab some coffee, and we appreciate you all joining us. So welcome to this particular episode of the Burr and Foreman Morning Show. My name is Nafela Helou, and I have been entrusted to be today's host, so we will see how that goes. I am an associate in the Atlanta office. And obviously a labor and employment attorney, have done that for, I'm almost to the point where I can say 10 years, but not quite yet. But have had the pleasure of working with many of you guys and look forward to continuing that. And today we're going to chat a little bit about employee handbooks and why they matter. And as the year end wraps up, why we should be reevaluating what we have and how we move into 2022 on the right foot. So I'm also joined by John Gumbel. John, if you will introduce yourself, we'll start there.
Good morning, everybody. Happy holidays. My name is John Gumbel. I looked at the guest list, so I've worked with many of you before, some I have not. I am also the labor and employment lawyer. I'm a partner in the Atlanta office. Nafela and I work closely together on a number of different matters and cases, and it's our pleasure to address this topic. I would say at the onset that we looked very hard for a topic that didn't involve COVID. We couldn't find one, so we found one that's sort of a hybrid. So we got quite a bit of COVID-related policy discussions at the end, but we also wanted to address something non-COVID because everybody's kind of tired of us hearing us talk about COVID. So I think you'll find this an interesting topic from both the COVID and the non-COVID perspective.
Yeah, absolutely. So, just to start us off, why is it so important for employers to review their handbooks right now? That's kind of, we have one. Why do we need to go back and look at it? There's several reasons. Obviously, COVID has kind of flipped things on its head for the last almost 2 years. And we've seen a shift of the workforce for many. We've seen more teleworking. We've seen different policies. We've seen different practices come into play in the last 2 years. So we need to make sure that we're up to date, that we have the policies that we need in order to do business the way we want to do business, and that our policies and practices are matching up. Surprisingly, since June, so in the last 6 or so months, they have had more than 100 different employment laws that have been enacted across the US. And obviously, this just shows that there is a rise of state and local legislation that we need to be paying attention to. It was kind of a long time ago, we just kind of had to pay attention to federal rules and the way the federal government was kind of mandating the employment relationship. But in the past couple of years, we've seen a definite rise of, state, and now I would say even more so local legislation where towns and municipalities are putting into play some very interesting employment statutes. The courts have increasingly relied on handbook provisions and seen them as contractually binding. So we want to be careful about what we put into our handbooks to make sure that we're not creating a contract with our employees. We have obviously seen some changes to employer responsibilities in response to COVID. And, as John said, we tried to find a topic that was not too COVID heavy, because I know everyone has COVID exhaustion, I'm sure, especially vaccine mandate exhaustion. But, we have seen some changes to things like that. And we'll chat briefly at the end about the vaccine mandates and where we go from there. And then lastly, it's just generally best practice to audit routinely. I mean, as I mentioned, we want to make sure that our policies and what we have in writing matches up with how we go about the day. So with all that being said, that's kind of a high level 30,000 foot approach to, why we picked this topic and why we wanted to talk to you guys about it this month. And with that, John, if you want to expand upon some of the most common mistakes we see when it comes to handbooks, that would be awesome.
Sure. And these are not necessarily in order of priority or danger. They're just issues that Nafela and I have seen over the years when we look at employer handbooks and some of the issues that may result if they're not done properly. So the first one I have on my list is the copy and paste handbook or the copy and paste policy. And I'm not being self-serving when I say that, in the sense that, there's a lot of good policy, pro forma policies on the internet, but what the conclusion we've always come to is that it's not a one size fits all type of situation where you can just adapt a handbook, have your employees sign it, and without giving any thought to who your workforce is, the personality of your workforce, the goals and directions of the business, and so forth. So sometimes canned handbook policies can be dangerous if they don't really fit your workforce. If it's not tailored to your workplace or your practices, it can create, and I'm going to explain this in a little more detail, risk when and if and when you are sued by an employee. The next one I have on my list is not including the proper disclaimers. This is both a general and specific area, and I'll explain that. From a general perspective, clients sometimes omit the necessary language that we all know should be in a handbook. That is the language that always states, this is not a contract, it shall not be contractually binding. The employer reserves the right to amend these policies without notice. Although that language may seem lawyer-driven, it really does make a difference. And so when clients forget about that or don't include the right language in their disclaimer in a general sense, it can create problems. Also, on the specific side, there's certain specific policies within the handbook that also will require some form of disclaimer. Generally designed to sort of preserve your autonomy to make decisions. One example, and this comes up often, is a progressive discipline policy without language preserving the right to, excuse me, skip progressive steps if it's in the company's business interests. That comes up, it's just a rough estimate, in more than 30% of the lawsuits we handle. Because generally when we terminate, we're going to terminate somebody outside the steps. They've done something that deserves immediate discipline or termination. And so plaintiffs' lawyers love to go after that language. So it's not just including that language, it's making sure that it's designed and worded properly. And if we don't have that language in there, we will be punished by the courts. The next one I have on my list is overly restrictive disciplinary policies. And the opposite would work too if they're too general and too bland and don't address the right issues. But more often than not, it's the overly restrictive disciplinary policies that we see as a problem in litigation. I'll give you a good example. So some folks have a disciplinary policy which requires an investigation for all forms of discharge or prior to all forms of discipline or prior to any discharge decision. To me, that hamstrings the employer too much. Unless there's a harassment allegation or discrimination allegation or some other allegation that could involve illegal activity or a claim that could involve illegal activity, we don't want to strap ourselves into doing an investigation for every discharge decision, and certainly not every disciplinary decision. So sometimes it's, we go too far in hamstringing ourselves. And a lot of the clients that are online with us today will tell you I'm more of a minimalist when it comes to policies and handbooks. That may not work for your company. And I'll give you a great example. If you're a multi-state company with a centralized presence of HR expertise, you may need a more detailed handbook because you're sending it out to managers in Poughkeepsie or Salt Lake City or wherever, and you can't handle all those calls. Or it may be better to have a more minimalized handbook, especially if you're just one location in Georgia, then you can go more minimal. So those are the types of things that we look at when we design a handbook or redesign a handbook. Overdrafting a handbook, very similar to the last topic, and I'm going to explain that a little more in the next section. Failing to ensure that our policies match our practices. This goes back to sort of the canned, boilerplate policy handbook that we talked about before. So if we're not designing our policies around our practices, are we a manufacturing? Are we service industry? Are we in the insurance business? Are we in, what business are we in? What are our goals? where are our employees at every day? Are they working overtime? Are they not working overtime? Too often, employers just sort of see a policy and they adapt it, and sometimes without even thinking about how that applies to their particular workforce or their business niche. It's nearly impossible to make sure all practices match directly with the policy. For instance, a detailed discrimination harassment investigation policy is usually not recommended, not by me anyway, not in a handbook anyway. And that would be a policy that describes each step, with all the specifics in it in the investigation process. So you get a claim for sexual harassment or racial harassment or discrimination. As a litigator, I don't love the idea of setting out everything we're going to do in advance, because investigations have to have, they have to be a work in process. It has to be looked at in the context of the claim being made, the number of witnesses, who's out there. Because if we lay it all out in the beginning, we have to follow that. And if we don't follow it, either the jury or the judge or the plaintiff's lawyer is going to make us pay for it. So those are the types of issues that we look at when we try to decide what's the best policy to fit our workforce. All right. So I'll give you another example. And this is one that has come up several times in litigation. If you have a probationary status for your employees, something about the first 90 days are on probationary status, and it says something along the lines of, you want to go beyond saying something like, for the first 90 days, you are on probationary status. We need to go further with these types of policies and talk about what that means. Does that mean that the normal attendance policy doesn't apply? Probably. If so, we need to state that in the probationary policy. Does it mean that the progressive discipline doesn't apply? It shouldn't in a probationary situation. So we need to spell that out. So there are some areas that we see that people provide too much detail, like the investigation, laying out the investigation in the handbook in detail. And there are some where some employers don't go far enough. And that is, what does probationary status mean? Okay, next problem we see, and that is failing to update out-of-date policies. Normally, that doesn't mean, pulling every potential new policy off the internet and adding it to the book. It means, have there been changes in a particular state's PTO law or locality PTO, or have there been states, for instance, under the Obama administration, we saw that they were going to try to amend the salary test for overtime. Have there been changes in that? That didn't go through. Those are the types of big pictures issues that we need to amend rather quickly once they're passed. Next problem we see is failure to consider the impact of state and local regulations. Nafela mentioned this earlier. We keep track of these for some clients, and as she said, there's been more than 100, I think, passed this year. Is that what you said, Nafela?
There have, just in the past 6 months alone.
It's absolutely mind-boggling how many localities, that means cities, counties, whatever, are taking it upon themselves to pass employment regulations and ordinances that affect your employees who live in that area. And it is a problem. You can't design a handbook that's going to be a living handbook that adjusts to each one of those situations. So one of the first things you need to look at is, where are we? Do we have remote salespeople in small counties in Illinois or North Carolina or wherever that are going to have a different PTO law than what we have in Georgia? How do we adjust to that? How do we design a handbook? We don't have HR people in those areas, so how are we going to deal with that? There's no two ways about it. It is a very difficult undertaking to keep up with that stuff. And those are the topics. Generally, those are the problems that we see with handbook policies. A lot of people have great handbooks. I'm not saying that they're all faulty, But we need to keep an eye open for keeping them updated, not putting in canned policies, not putting in policies that we think are just cool, and not worrying about how they impact our workforce.
Yeah, and we'll get into some of these a little bit later on. So let's go ahead and kind of break down that really big picture of that was a lot of issues that we have kind of tagged and issue spotted, and let's break them down a little bit. So John, at the beginning, you said that, one of the things that you see a lot is overdrafting a handbook. Can you explain what overdrafting a handbook would look like or give some examples of that?
Sure. And I've given, I think, a couple examples already, but I'd love to get into a few more. This goes more into the over-inclusion of policies than what I'm talking about of too much language within one policy. For instance, and these are just really suggestions for you to think about it before you adopt a policy and then later believe, oh my gosh, I might have thought twice before I would have adopted that policy and included it in the handbook before. One example is I often see ADA and ADA accommodation policies in handbooks. And there's nothing wrong with those policies as long as, in my opinion, they remain fairly general. The ADA is, as everybody knows, the Americans with Disabilities Act is a very complex set of moving target rules. And each case that we deal with under the ADA, whether it's just a prospective discharge decision or whether it's an actual lawsuit, involves different facts. So I look at ADA policies with sort of a critical eye. And if they get into too much detail about, our commitment to accommodation practices, then we may be hamstringing ourselves or strapping ourselves into decisions that we don't have to make when the situation arises. So they have to be very carefully and, in my opinion, generally worded so that we don't pin ourselves down too much. We want to be very fluid when it comes to decisions regarding the ADA. Nafela and I have a case right now that is, it is very complex from an ADA standpoint and an accommodation standpoint, and involves work from home and all of the issues that you think about with COVID. If that particular client had designed a commitment to accommodation policy that was detailed, we may not be fighting that case as well as what we are right now. So be careful about overcommitting in those types of areas. Another area is the benefits area. Sometimes I see handbooks with very, very detailed policies regarding employee health and welfare benefits. And one problem that I see is that those policies don't defer to the language of the plan, which they always should, because the insurance plan language is your best friend in an ERISA case. And frankly, I'm kind of, over the years, I've come to, my opinion is that I'm not a big fan of any sort of detail when it comes to insurance benefits in a policy handbook. I think it's fine to say, here are the benefits we offer if you're eligible, and eligibility and all other criteria are determined by the plan language. But when employers try to get into significant detail with that, it creates conflicts with the plan, and that creates problems down the road in litigation. This type of over policing is fairly regular. It's not against the law, and it's not a legal problem. It's more looking at it from a litigator's eye and saying, okay, where are we going to trap ourselves down the road? How is the jury, the judge, or the plaintiff's lawyer going to use this against us?
Yeah, that definitely makes sense. And you know what, actually, guys, this is my first time hosting, as I said, so I forgot to talk about some of the housekeeping items. So as we go through this presentation, I'm going to segue real quick and we'll come right back to it. But as we go through this presentation, you all should see a Q&A button down at the bottom of your screen. If you have questions, feel free to submit them. This is not as interactive as it would be if we were all sitting around a round table, but we welcome your questions. We're happy to answer them as best we can, and we'll address those as they come up. Or if you guys, have any specifics or need us to elaborate or anything, feel free to drop those in that Q&A, and we'll be on the lookout for those. So I'm sorry that I didn't mention that at the beginning, but we are more than happy to answer those questions. So getting back into it, and I'm sorry, John, getting back to the overdrafting the policy, you said, you kind of talked a little bit about some of the policies that are kind of problematic because we don't want a judge or a jury to ding us for having them. You know, what policies do the courts, are they most likely to interpret as contractual on the same, kind of in the same vein? What are those policies that we need to pay attention to make sure we don't create that contractual obligation?
Okay, that's great. And let me sort of explain that, because I think it's important and we didn't drill down far enough on that. So when we say every handbook or all of y'all's handbook should have the language in it that says this is not a contract, right? That's where we start. And that all makes sense, and that's necessary language, and we talked about that at the beginning. When we say that there's a danger of it being considered contractual, this is what we mean. Even though that language says it's not a contract, most judges and juries will treat it as if it is a contract in many circumstances. So no matter how much we say, well, here's the language saying it's not, if you have a strict progressive discipline policy that says step 1, 2, 3, and 4, and you don't preserve the right to jump steps or skip steps, then a lot of judges and juries, once you do skip steps and it's challenged in court, are going to say, wait a minute, they had to give them that right. They did not give them the third warning before they discharged them. We're going to hold them liable for that. So it's one thing to say in the handbook it's not a contract, and what that really means is our employees can't sue us for breach of contract if we step outside of our handbook. But practically speaking, juries, you can't convince a jury that it's not a contract, no matter what that disclaimer says. 90% of the juries are going to say, well, you made that commitment, so you have to live with it. Now, to Nafela's question, you know, what are the policies that judges, juries are going to normally consider as contractual in the heat of battle? Well, discrimination policies is one. If you don't have one, that's a problem. But if you overcommit and say, you know, part of our EEO policy is we don't allow bullying in the workplace, okay? Then there's no legal cause of action for being fired because you complained about bullying. But if you have that in your EEO policy, if it makes it that far, the judge and jury could consider it contractual. Investigation policies are often considered contractual. That goes back to my example before where we're talking about overcommitting on the investigation on the front end. So if you're going to put detail in an investigation policy beyond just we will investigate the harassment claim and we will provide results of that, and we will take prompt and remedial action if there's a violation of the law or the policy. Anything beyond that, such as step 1, we're going to go here, step 2, we're going to go there, we're going to talk to every witness in the whole facility and so forth. If you go that far, you could be bound by that in a contractual way. I mentioned anti-bullying policies. Those became very popular in the last few years. I personally am not a big fan of those policies, and the reason is that bullying is such a nebulous term and such a subjective term, right? We all feel bullied all the time, but when you put an anti-bullying policy in, my take on it, and I see a reason for it too, but my take on it is we're really putting our HR department out there to investigate a lot of issues that may or may not be a real issue. Overtime exemptions. One of the areas I see over policy or overtime exemption, trying to describe what exemptions apply and what the factors are. That overtime exemptions are based on thousands of cases, maybe millions, that have all arisen since the 1940s. So to try to put that in a policy, more often than not, sort of hamstrings the employer into putting people in categories. And frankly, there's so many fuzzy, blurry areas of an administrative exemption that you really don't want to stake yourself out on that. You want to deal with it on a case-by-case basis. And I mentioned before, ADA and accommodation policies. I think the typical ADA policy that says we won't discriminate against the disabled and we will accommodate if provided for by the law, those are fine. But where we talk about how we're going to accommodate, the various ways we're going to accommodate, those can be considered contractual commitments by judges or juries.
Yeah, absolutely. John, I'm sorry. I feel like I've made you do all the talking. So I guess I can carry my weight here and move on and kind of expand upon, the danger of having policies that, kind of don't align is the term we used with our practice, or having out of date policies. And to clarify what we mean by that is, really just what John kind of already said, in terms of, we really don't want to have for example, I'll use the disciplinary policy because it is so common that we get complaints from employees who say, well, so-and-so was treated differently. And it gives rise potentially to discrimination claims, because we've really tied our hands in how we respond to employee complaints. And if we don't follow our roadmap, to a T, essentially what we've done is we've handed over. One of the first things a plaintiff's attorney is going to do is ask for our policies. That's going to be something that, they're going to ask, and they're going to review, and they'll take a highlighter to it. And they'll say, well, here are all the ways that you treated my person outside of what you said you would do. And so that's a problem. Obviously, there's confusion. Sometimes, employees will read it and they'll say, okay, well, this is how I should go about things. And then, if that's not how it actually shakes out, then, it leads to confusion, and it leads to misunderstandings that can ultimately, if it gets bad enough, they seek out counsel. And then when plaintiffs' attorneys get involved and such, it's almost like we've sailed too far down the river to turn back around. And then having out of date policies. What we mean more so by out of date policies, as John said, are just how fast things have changed from the Obama administration to the Trump administration. And, just looking at federal law from the Obama administration to the Trump administration to now the Biden administration, it kind of leaves your head spinning. And if your head's not spinning, I mean, call me, because I'd be interested to see how you're taking all of this in. But it does leave your head spinning to see how things have just kind of evolved and changed. And we had Obama put forth some regulations, for example, with labor union issues, and then under and joint employer liability. And then the Trump administration kind of undid all that stuff, and it left a little bit of gray area because we weren't really sure exactly how joint employer liability shakes out. And now we have the Biden administration who's coming back and trying to fill in the holes, and it's all over the place. So similar to what John said about, the FLSA exemptions, we kind of have several different areas where we just really don't want to lock ourselves in. And we want to make sure that what we have in our handbook, especially if we have a centralized HR team who is sending the handbook out to managers, and they're really utilizing it as a guide on the law, we want to make sure that it's accurate, and what they, perceive to be the policies, match up with the law. And on that being said, I mentioned the federal, but as we mentioned earlier, there are hundreds of state and local regulations kind of floating around. And, how do we monitor those? It's complicated. John and I and several, Burr offers, where we send out just kind of a monthly update of, here's all of the changes that took place in the last 30 days for the month of October, the month of November. And we just kind of send those out at the beginning of the month for the clients who, are interested in that kind of thing. If that is something you'd be interested in, feel free to shoot me an email. It's something that generally is a little bit more active when we have the states and all in session, and it'll kind of wane and it'll pop up, but our emails will be at the end, so I can discuss, how we go about that and what that looks like. But, a lot of times people think that these state and local regulations are in kind of the places that you would expect. California, New York City. I mean, we see in the news every day that New York City, not to bring up vaccine mandates too early, but, we see that New York City is implementing things. We see that LA has implemented things, Miami. These are the cities that kind of make you think, okay, I expect there to be something funky in Chicago. Let me take a deeper look, kind of do some things where, my spidey senses are up a little bit. But we're actually seeing them in a lot of places that you would not expect. Columbia, South Carolina, some, places in Tennessee, some cities in Georgia. And those are kind of the things that you're like, oh, I never really would have expected, Columbia, South Carolina to have a PTO policy that, we have to abide by in order to make sure that we're compliant. And I think one of the areas that John and I often run into issues with are PTO policies, vacation and sick leave. A lot of localities, there are cities in New Jersey, there are cities in New York, Chicago, all over the country, who mandate that, if you have an employee, they have to accrue sick leave at this rate. And if they're not accruing sick leave at this rate, we get into a little bit of trouble. We can, there's sometimes in some cities, there are penalties that they'll automatically charge. There are different, punitive things in place that create issues for employers, and they can add up fast. The other thing I'll say about, PTO and sick leave policies and the way that, they're viewed in some of these tiny little areas, states, or, these cities and all, is that sometimes we have policies where use it or lose it, or if an employee's employment terminates for any reason, they, are not entitled to a payout of that. And sometimes we get into it where we're separating an employee, and the employee says, hey, by the way, you owe me all of this paid, vacation or paid sick leave or whatever that you took or that I didn't take. And the company's like, no, we don't. And it kind of gets into this issue of, well, actually you do under this tiny, Philadelphia law. And so kind of being aware of those so that we can not get into a situation where the employer is paying out, a large lump sum of PTO at the end of the day. Generally speaking, under most of the regulations, we're able to limit that. We're able to give some sort of, we're able to control it a little bit better than we would. And so, just paying attention, looking for those in the places that we don't expect them, we're always happy to help, but just kind of being aware of those. And, as John said, it's for our multi-state, multi-jurisdictional employers, it's really hard to say, okay, well, how do we have a handbook that is applicable to the company as a whole and puts forth who we are as a company, but also addresses all of these little, issues that come up for employees in California or employees who are in Florida and have, different leaves, for example, that then, some places have mandatory, paid maternity leaves, whereas others don't, or, they have, organ donation leaves. I've seen those in some places. Witness leaves. Those are just some examples of leaves that we need to be, aware of that employees are technically entitled to. Some places have paid jury leave and then others don't. So we need to make sure, to the extent we want to, not every leave we have to outline in a handbook. I will say that. So we don't want to over, draft the handbook, as we say. But for the ones that we do need to include, we want to make sure that those are included and that they go to only really the applicable employees. We don't want, John, correct me if you disagree. I mean, feel free to hop in at any point, but we don't want to list out, all of these leaves and then make them available to employees who may not be entitled to them as a result of, their location. And so I'd say probably when we sit down with a client to evaluate or adjust or redraft or even sometimes draft a handbook, I think one of the initial conversations we have is, where do you do business and how do you want to approach this? And, so when it comes to integrating these, these local laws, state and municipalities and cities and such into a handbook, what we often do is we'll have a main handbook, and, some of the options are to have addendums. So it goes out, this addendum will go out to our Florida employees or our Georgia employees and so forth and so on. And then, sometimes companies, there are so many differences, they opt for individual handbooks. I think that's probably much, much rarer than the state addendums, but just, making sure that we have those and we have evaluated how we want to get this information out to our employees, in the best way we can. That's something that we're always happy to help you guys with, especially if you find yourself in a situation where, you're coast to coast and you're like, okay, well, how do we get this information out to our employees? That's, one of the things that we do, I'd say most often when it comes to these handbook draftings. John, was there anything you wanted to add?
Yeah, just one point. I think, Nafela mentioned Columbia, South Carolina, and I think I've mentioned Poughkeepsie just as an example, and California, San Francisco, LA, all of the usual culprits we think of when it comes to strange local laws. But the tricky part of this is, in your brain, you're saying, "Whew, thank goodness we don't have an office in Columbia or San Francisco or Los Angeles." There's going to be more and more businesses going this way, where there's a lack of bricks and mortar outside the state of Georgia or wherever your home office is. You can't stop thinking about this, because a lot of you all have remote salespeople or insurance adjusters or whoever it might be that are living in Columbia, South Carolina. The general rule of thumb is that if they live in that state, it doesn't matter where they report to, they are probably entitled to that additional PTO benefit that Columbia offers, or the maternity leave that San Francisco offers. So you can't just think about where we have an office or where we do a majority of our business. You have to think about where that employee resides. And as Nafela says, if we're making your head spin, we're not trying to, but this is truly a head spinning issue. And this is why we chose this topic, because there's really no way to simplistically, you would have to have a full-time HR staff dedicated to handbook policies in order to keep up with all of this. So we struggle with this too. We're trying to find a way for our multi-state employers and our employers with employees in distant states to keep up with this craziness, as I call it, and adjust on the fly and make sure that we're offering the right benefits from a state and local level. So that's my addition to that part.
That's a great point. And, we have a situation with an employee who lives outside of California, but, we have a client who assigns employees to do work outside of where they live. And some of these statutes say that it applies, there's different thresholds where once an employee has worked so many hours in their jurisdiction, sometimes even they're more rare than living there, but there are some, mainly in California, I'd say, that do say once an employee hits this threshold of work, we consider them for purposes of our, I'm going to use California because I've dug into theirs, for purposes of our employment statutes, they're protected under this. You can't, essentially pull in employees from outside the state to evade the way that we like to treat our employees is kind of the way that the California courts have said it. So that's a great point, John. Where your employees live and potentially where they are performing their duties, if they meet those thresholds, is important. It's just not where we have our brick and mortar stores. Okay, so unfortunately, we are coming to the time where it is time to talk about the elephant in the room, and that is COVID. So, yeah, we're back. You knew that.
To the end.
Exactly. We put it off to the end for as long as we could, guys. But I don't think you can talk employment policy right now without COVID coming into the picture somehow. And kind of, John, really broadly, what are the areas, in taking the calls that we've taken over the last 2 years, what policies do you see that have been especially impacted by the pandemic where, we want to maybe give those, some additional thought just in light of the realities of doing business these days?
Okay, let me qualify with what I'm about to talk about. With, as you said, Nafela, I think it's hard to find anything that's not touched by COVID in the employment law world. And so when I talk about these categories of policies that are impacted, they're impacted. Some of them are impacted directly by COVID. Some of them are impacted arguably by the labor shortage, which could be impacted by COVID. Some are impacted by inflation, which could be impacted by COVID. Who knows? But I'm kind of lumping all these together. So the first one is your attendance policy. Now, that is really more of what I see as a labor shortage issue than it is directly a COVID issue right now. But, I would say that let's face it, a lot of our clients have had to relax their attendance policies because of the labor shortage. We need warm bodies to do the job. So The challenge there isn't so much with your policy, it's right sizing your policy when this is done. So, and I'll take a simple example. If you've got a 10-point system that says 10 absences and tardies, you're going, right? During the labor shortage, we were allowing up to 25. Well, that's fine. We sort of did it across the board and we had to do it for business reasons. But now clients are starting to bring that back to reality. They're saying, oh, we can't continue to allow 25. Where you have to be careful there is from a discrimination perspective. Are we impacting one group more than the other? Are we saying, well, you had 25, now you get 15, and another group we're saying, you had 25, now you only get 10. We got to find a way to readjust back off of the COVID craziness for most attendance rules or policies. This may involve amending your policy. More than likely, it might involve giving notice to your employees, which I think is a good idea, that we had to do this for business reasons. We are now coming back, hopefully from COVID. Now we're going to enforce it this way. And I think advance notice, it really helps protect you from expensive litigation. Work from home policies is my second category. And we just dealt with this yesterday. You have to first decide whether a work from home policy is a good idea. There's a lot of pros and cons from that. The number one problem in my mind that comes from a work from home status of employees is monitoring and making sure that we're adequately compensating them for overtime. There are other ancillary problems, but I think if you're going to draft a detailed work from home policy, when your practice has been working just fine, then you have to ask yourself, if it's not really broken, should we try to fix it? Because work from home policies are one of those areas, in my opinion, where you could over legislate yourself. Sick leave policies, obviously that got all crazy during the Family First era, and how are sick leave policies affected by that? I don't know, Nafela, I haven't seen a lot of problems in that area, but I included it in my list, and we may see problems down the road. Sort of the rule of thumb that we've approached COVID with is if it's an FMLA qualifier, certainly they're entitled to sick leave if they have COVID or have tested positive for COVID. I think where employers got a little confused was they started applying a lot of their sick leave policies during COVID to relatives of employees, and that may not always be necessary. And as we call those back, we need to look at that. Do we need to provide a notice to our employees that the policy is a policy and this will no longer be the case? Or those are the things we should be looking at. Call out policies, always a problem. So that is the procedure you use for recording when somebody calls out sick. We've been dealing with that under the FMLA for a long time now. And I think it's really important to make sure that our call out policy is strong, that we have a system in place for calling out and keeping those reasons somehow in a file. I know one of our clients who's here today has a great system, I think it is, where they call into a particular number. I think it creates an email recording of the call and then sends it to HR. And then that's kept in a file, because down the road in an FMLA lawsuit, a lot of times they're going to say, I was out because of my knee or my hip or my back. But when they call in, they'll say my car broke down. That's not FMLA protected. So we need to make sure, and this is outside of COVID, but it's impacted by COVID. We need to make sure that those call out policies and procedures are detailed and that we're keeping records of that. That really helps us in the event of FMLA litigation. That's all I've got on that one.
I think I'll just add, because I've seen an increase, and John, tell me if you have as well, where we're dealing a lot with employees or employers who are toying with the idea of when it comes to sick leave, PTO donations and things like that. And, those questions and how we won't give our legal advice on those. But, when it comes into sick leave, we're not talking just, sick leave and things like that. I mean, last year we were dealing with the Families First Corona Response Act. We were dealing with all these different things, and luckily those have gone away, but some states still have extra protections for employees in light of lingering COVID effects. And, we started to see an increase of employees hey, asking like, can I, this employee is, really struggling with so forth and so on, and I'd like to donate PTO donations. And I've gotten a lot of those calls recently about how do we feel about PTO donations. So things like that, when we say sick leave policies, it's just kind of with COVID and everything going around, that's kind of what I think of as being some of the policies that have surprisingly kind of come to the forefront in the last, year and a half or 2 years. So that's all I'll add. Well, John, I think now is the time that we get into our vaccine policies. So if your head wasn't spinning before, I will try my best not to go ahead and kind of set it off, but there has been a lot going on with vaccine policies, vaccine mandates, where they stand. As you all know, there are essentially 3 different mandates that have come down from the federal government, and we have a mandate that goes through CMS to anyone who provides services through Medicare or Medicaid. We have a private employer mandate through OSHA, and we have a federal contractor mandate that comes down, from that line of things. So, okay, overall, every single one of these mandates is stayed nationally. Really quickly, I will just touch on kind of where we are. The CMS mandate is stayed nationally. At the end of November, federal courts in Missouri ruled for an injunction for 10 states saying that CMS could not enforce their vaccine. This is our Medicare, Medicaid folks, could not enforce their vaccine policy in those 10 states. The next day, a federal court in Louisiana issued a injunction for the remaining states. So effectively, when read together, that's put on hold entirely. I will notate that permanent injunctions are not, and preliminary injunctions are not permanent. It's essentially just telling CMS that they are not able to pursue or enforce their vaccine mandate until it has been thoroughly heard by the courts. The next one is OSHA, and that is probably the one that will affect most of you guys, if not the federal contractor ones. This is the one that says, hey, employers with 100 or more employees will need to confirm that their folks are fully vaccinated or have a weekly testing, a weekly negative test that they have to present in order to come in and be on a work site or in any sort of, office or any place where we're doing business, essentially. So last month, the Fifth Circuit stayed that nationally. And so that has been stayed for a while now. It was then through the lottery, it went up to the Sixth Circuit. OSHA, just so you guys know, filed a motion for them to lift that. That could be ruled on anytime after December 10th, based on the deadlines that the courts have given. Let's see, I just want to make sure I don't miss anything because there's a lot here. So I've got some notes.
Hey, Nafela?
Yeah.
Can you explain to the audience, we use the word stay regularly in litigation, but I think it would help to just sort of explain what that means.
Sure. Sorry. Yeah, that's one of those things that I feel like I've lived with since we got these, and it's one of those words that unfortunately I say all the time. So essentially that just means that it's halted. When it's stayed, that means that it's kind of frozen. That's the best way. I mean, John, you can probably actually explain it a little bit better than I can, but I think of it as just, it's frozen. They're not allowed to move forward with it. All of the deadlines that are associated with their mandates are not effective. It's essentially just kind of putting it on ice until the court says, hey, you can move forward with this, or says, this is unconstitutional and we are not able, or OSHA is not able at any point to put it into practice. So it's kind of one of those things where it's a pause, I guess. John, do you want to expand or clarify?
Yeah, I just add to that just a little bit. It essentially, and this is really big picture, okay? It means that if you're covered by the 100 employer OSHA regulation, or if you're covered by the healthcare regulation, or if you're covered by the government contractor regulation, you currently don't have any legal obligations when it comes to a vaccine mandate. Now Nafela's going to talk about should we undertake anything, but currently you can't it's all stopped. We can't predict with any certainty where it's going to go. I think the Vegas odds with the private employer 100 employee OSHA regulation mandate, the one that covers the most, is that it probably will not survive, but we can't say that with certainty.
Yeah. And I'm not an expert, and I'm not going to try my Vegas odds, to be honest with you, because I have not won the lottery yet, or, not that lucky, unfortunately. But, everything I'm seeing from people who are much smarter than I say that, this really probably is not going to stand. I mean, in terms of the OSHA mandate, once we have a ruling from the Sixth Circuit on the current stay, most likely it will go up to the Supreme Court. And from the legal experts, that I've been following, they're saying that the Supreme Court would really have to put pedal to the metal, as they say, in order to have a ruling out by when the ETS will expire, which is May 4th, 2022. So that being said, this was a 6-month emergency temporary standard that OSHA put forth, and so it will expire regardless of where the courts go with it on May 4th. Obviously, there would probably be some sort of extension, but I'm really hoping we're done with COVID by then. Maybe I'm just, still naive. I was one of those folks that thought, hey, 3 months will be good. No, I was really wrong. So don't quote me on any of these Vegas odd things. But from an OSHA standpoint, it seems like a stretch. I will note that we have had some lawsuits that have sued in order to expand the OSHA regulation to smaller employees. I wouldn't even worry about that. If you're seeing those headlines right now, I think I wouldn't worry about those. The federal contractor, as of earlier this week, a Georgia federal judge stayed those federal contractors. So essentially, no matter which mandate applies to you, how they get to you, or what your mandate looks like, you don't have any legal obligations right now. That being said, as John, mentioned, we really don't know where this is going to go. We can guess. Each mandate is different. Each mandate is put down through different rights, through different, rights that are assigned to the federal government. For example, that yesterday or Wednesday, Congress actually voted to block the federal contractor, and Congress, the Senate voted to block the federal contractor mandate, essentially saying that, they have the power to review executive orders, and that they thought that President Biden had, stepped outside of that. That's not likely to survive the House. And then, it would go up probably to President Biden, who would veto it, even if it did survive the House, and then it would come back down. So people don't expect that to survive. But just so you know, there's a lot of moving pieces that make these mandates very hard for us to practically decide how we want to go forward. So with that, we'll kind of wrap up now with talking about how, or should you guys be thinking about these vaccine mandates? Should you be preparing for them? And if so, what will that look like? And, John, feel free to hop in at any point, because there's just so much, kind of floating out there right now. But like I said, there's so much uncertainty. There's really no real timeline for when these decisions will come down. Like I said, this ETS will expire on May 4th. For the OSHA ETS, the court could rule on the DOL's motion to lift the stay anytime after December 10th, just based on deadlines. But there's no, kind of line where we'll see those. We don't know if the Supreme Court, we all think it will, most likely. If I was going to bet and say you could probably take this, I do think it will go to the Supreme Court, but there's no guarantee. If they do survive the various challenges, the CMS, all of these vaccine mandates, if they do survive the various challenges, we don't have a predicted timeline for deadlines. Obviously, the OSHA deadlines, a couple of them have passed. So the December 4th deadline has passed. We really don't think the January 4th deadline will be able to stand. So we're not really worried about those particular deadlines. We just don't know how it will come into effect. Due to all of the uncertainty, we're getting a lot of calls that are like, okay, how do we go about this? What should we be doing to prepare? And as John said, we don't have any legal obligations right now. There's nothing that we have to do. So first we have to look at, is there a reason that we would want? Some employers are going forward with vaccine mandates. We've seen them from Google and a lot of other large employers. We've also seen them with some employers that place employees at other work sites who their client is essentially saying, hey, we're going to go forward with this. So we expect you, for those folks, so they're kind of looking at it from that standpoint. But that being said, if none of that is, if you're just looking at it from a what are our legal obligations standpoint, you don't have any. But if you want to be ahead of the curve, and John, feel free to jump in, disagree, or whatever. There are a lot of employers who, due to the size or the nature of their workforce, are starting to at least audit their employees. One of the requirements is that we have a list of our employees that includes all of their vaccine, status. And some employers have opted to, there's really no harm. They're not putting anything into play. They're not mandating vaccines. They're not mandating testing. They're just essentially collecting the data so that, if these things survive in any form that would apply to them, they're prepared to move on to step 2. Some of them think that that's really helpful because we've drafted a lot of surveys, and in those surveys we'll include, questions like, yes, I'm fully vaccinated. I am not fully vaccinated, but I will be vaccinated if I have to. And then we've got some we also ask, some employees can say, I am not vaccinated. I plan on seeking an exemption. So it can be helpful to have an update or to have a heads up about how many exemptions we may need to process if this survives. And then we also have I am not seeking an exemption and I am not getting vaccinated kind of option. And that just lets us know, how this may impact our workforce. Do we need to look at, do we have a large percentage of our workforce that we may run into issues with if we are required to mandate vaccination? And it's just kind of, I think some folks are looking at this from a planning perspective for staffing. We're already in a labor shortage. I mean, what kind of impact would this have on our workforce if it does go through? And those are kind of the arguments that folks in Congress and, and in the court systems are using to argue against a mandate. We're already in a shortage. We're already suffering economically, from COVID and things like that. So why are we going to just kind of put on, add to that fire? But folks kind of like to be prepared, and that way that's going to be kind of a long process they've looked at, especially the larger their workforces are. So they've kind of started that process just to collect the data, so they know where to go and they can plan accordingly and say, if these go into effect, here's how it's going to look. Here's what we're going to do. Are we going to offer a testing? Do we need to offer a testing? If we have, 99%, do we need to offer a testing if, 99% of our employees are vaccinated? That's kind of how they're looking at it. That is, a handful of folks. That's not everyone, but that's something that many are considering and think would be helpful. I will say, when you're doing that and conducting the audits, just be cognizant of employee privacy laws. We are collecting medical information. So, keep in mind that we need to be protecting that information. We don't need to be sharing it with folks who are not in a need to know position. And, how we collect that may matter. But if that's something that's if of interest to you all, feel free to reach out. But a lot of people just think that puts it in a better position should any of this legislation survive. But it's so kind of nebulous at this point that we don't really know where it's going to go. John, I'm sure you have lots to add to that.
Yeah, not lots. I would just add, and you may be interested in this, but let me say this is just personal to me, but in my experience. But I would say the vast majority of the clients I deal with are, in light of the injunctions and the stays, doing nothing right now. Now, the danger of that, as I see it, is that if these survive, especially the 100-employee OSHA rule, if they survive and the courts don't sort of give us any clear indication of the deadlines for the questionnaires to how many folks are vaccinated or not, or whatever, we're sort of going to be in that murky world, or they give us a quick deadline, then you might be scrambling a little bit to get this information. I don't think they will hamstring you that much. So the vast majority of the employers right now are laying back, and just crossing their fingers, hoping this doesn't pass. And but if for your business need or your cultural your business culture need, you feel like you need to move forward, there are clients who are doing that as well. I think it's fascinating in that a lot of it depends, you may have 90% of your employees vaccinated and not have to worry that much, as Nafela said, or you may be like some of our clients who have less than 15% of a workforce of 400 or more who are vaccinated and probably aren't going to get vaccinated. And then you have to think about it that way. And a lot of it depends on, whether you agree with that or disagree with it, to where you are, what type of business you have, and so forth. But I would say, in closing, the vast number of clients I deal with right now aren't moving forward with.
Yeah, I would agree with that. And guys, I know we are about 2 minutes over. We have a question that came in, and we'll answer that. And then if there are any other questions, our emails will pop up on the slide at the end. Feel free to shoot us an email, give us a call. We're happy to talk about this. But the question that I got is, and I'll share this. What is the status of the prior OSHA ETS from June? Does that have an expiration date? So I'm guessing that is the most recent OSHA ETS that we talked about. And this probably came in before we really talked about it, but it has stayed nationally. And so you don't have any obligations under that. That is the one that will expire May 4th. It is currently pending in front of the Sixth Circuit Court. They have consolidated all of that. Like I said, the DOL filed a motion to lift that stay, and the court can rule on that anytime after December 10th, so today, if they want to. And that's the one that we think, John, if you disagree, say so, but I think it's going to go to the Supreme Court. And a lot of the legal experts are saying, based on the way the Supreme Court works, they would really have to move quickly to beat that May 4th expiration deadline anyway. And the OSHA ETS, so you have no obligations. That's probably the one, if I had to bet, like I said, Vegas odds, that's probably the one that would be the least likely to survive. If some of them were to not make it, I would bet it would be the OSHA one. But again, we can't say with any real certainty. John, if you have anything to add?
Nope, I do not.
Okay.
Other than to wish you all a wonderful holiday with your friends and your family, and a much needed rest after this year.
Perfect. Thanks, everyone. Have a very happy holiday.
Thank you.